be recorded.
Is the city on yet?
Thought it was you.
They may not be on yet. I'm physically down at City Hall and they have not yet opened the doors.
Oh, there we go.
Paul Michael Hicks. Hey, Mike, how you doing? I saw you getting in the car. I wonder if I could use your leaf blower today.
I think I gotta take it loose and do that little line. The thing you pour, it won't come out straight.
Yeah,
This call is no longer being recorded.
I've had enough.
Okay, Mr. Bradley, you need to mute.
Okay. Okay, I'll see you when you get back.
Okay.
Bye. Tim?
Yes?
Yeah, this is Howard Bradley. What's happening? Something happening with Carmella now?
What's that?
Are you in City Hall?
I am not in City Hall. No, I'm sorry. I'm one of the people waiting for my hearing.
Okay.
Yeah,
okay.
Howard, we're
Hey.
on now. Howard, can you hear
Hey.
me?
I hear you, man. I hear you, man.
Okay, yeah, just mute down. She'll be on shortly. There was a little
Okay.
delay.
All right, no problem.
Okay.
Thank you.
Happy Wednesday, everyone. Please mute your microphones until you hear your docket number call. Once you hear your docket number call, you will hear a brief synopsis of your docket case this morning. You will be sworn in by the chairman. We ask that you identify yourself and your relationship to the property before you give your testimony. If you are currently present in room 516 this morning, please silence your cell phones. And when you hear your docket number call, you're going to come up to the table and you're going to sit to my left. You'll press the red button in front of you on the microphone to begin giving your testimony after you state your first and last name for the record.
Will you be going in order of the agenda?
It's up to the chairman, ma'am.
Okay, thank you.
Yes, yes. And Ms. Davis, are we gonna have Mr. Gates or Mr. Jacobson on?
I'm not sure which code enforcement officer will be speaking this morning.
Okay,
It's gonna be Russ Gates
okay,
as well as Stan.
okay.
Mr. Chairman, we can go ahead and start with the preamble.
In compliance with notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1796, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conduct their meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record before the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile versions and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also use the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located at the bottom of the WebEx screen. All meeting activities being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comments on a particular matter. Okay, Mr. Gates or Mr. Jacobson?
Yes, Mr. Chairman. This is Russ Gates from the Law Department. It's a preliminary matter. The live stream, can we verify the live stream is on and functioning?
Through the chair to Mr. Gates, yes.
Thank you. And as the Law Department has done since these public meetings have gone virtual, law states its objection to the use of the chat function. Thank you.
Okay, thank you. Ms. Davis?
Mr. Bradley,
Here? Did you hear me?
Mr. Dink,
Here.
Ms. Lipscomb,
Here.
Mr. Gallagher.
Here.
We have a quorum.
Okay, we call the first docket, building docket A 125-25, 9110 Superior Avenue.
Application and fees are in order. The notice of violation is hazardous conditions issued on April 10th of 2025. Appeal was received on May 10th, 2025. The board is in receipt of the city's motions to dismiss this appeal. Present for today's hearing, Chief Building Official Tom Vanover. Will the applicant or his or her attorney and a representative please state your first and last name for the record?
Brent Warren, representing myself.
Okay, Mr. Warren, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay, go ahead and proceed.
Excuse me. I don't mean to interrupt. However, in the city's motion to dismiss, it's the contention of the city that this hearing cannot go forward because the board does not have authority to hear the appeal based on the law, the ordinance. So I believe this matter should be taken up first before hearing any testimony or presenting any type of evidence. So I apologize for interrupting, but the city would request that the motion to dismiss be ruled upon and granted.
And what are the reasons for that, Mr. Gates?
Yes, Mr. Chair. Basically the board is a matter of law. The board does not have the authority. It does not have the jurisdiction to hear appeals outside of the 30-day time limit. This appeal was submitted more than 30 days after the city issued its violation notice. And as a matter of law, it's inappropriate for the board to hear the matter. It should be dismissed. And,
Okay, I understand.
and just if I could just say one more thing,
Sure.
Is that the Court of Appeals, the Ohio Court of Appeals for the 8th District, and also the Federal District Court of Northern Ohio have looked at this in the past, and we did cite that in our motion, and they both stated that any decision by the board after the 30 days is a nullity. So that's one of the reasons for our motion. Thank you.
Okay, thank you. I have to ask the appellant a question or two. So, Mr. Warren, when did you actually receive the notice?
In April.
What date?
April 10th.
April 10th. Okay. And to Ms. Davis, when did you receive that information back?
Mr. Chairman, this appellant lives out of state in Baltimore. When he contacted the office, he mailed in his application. The application was received timely, but the payment was not correct. We reached back out to him to make sure he submitted the correct payment amount of $130.
Okay, so,
And that we received it.
okay, so we're in receipt of it in the timely fashion of the 30 days, but he did not pay the correct amount or any amount until after that particular time. So he did respond within the 30 days. Board?
May I actually came, because of that, I actually walked it into the building. So I came in person with the updated application as well as payment.
So
Okay.
it's just to be clear to the board, from what the city has before it is an appeal that was filed on May 10th.
19th.
Oh, I apologize. It was May 19th, which is I believe May 10th would have still been 31 days, but May 19th is definitely beyond 30 days. So that's what we're looking at, is the fact that it came in on May 19th, and the ordinance, as far as the first date that matters, it was issued. The decision was issued or rendered under the ordinance, the language of the ordinance. It was rendered on April 10th. So that's what we're going by.
Okay, so Ms. Davis.
Mr. Chairman,
Yes.
the application was received on May 10th. The appellant came in person from Baltimore and submitted payment on May 19th.
Okay, so what the board has to determine is whether it's when he met the 30 days, or do we consider the payment coming in afterwards? So I'm asking the board an opinion on that, which is going to dictate the 30 days. We have any opinion on that?
Yeah, Mr. Chairman, if the appeal was filed on time and there was just a confusion or a mispayment, I'm in favor of continuing to hear the appeal.
Okay. Ms. Lipscomb?
I agree.
Okay. And Mr. Bradley?
I agree.
Okay. So
Discussion?
yes, go ahead, Mr. Gates.
Thank you. City's contention is that the entire appeal needs to be appropriate to be considered filed. So we would say it's late under that circumstance.
You would say that the 30 days, you would consider that date you're considering the 19th or the 10th?
It's the 19th because it wasn't properly filed on time. And I was wrong previously when I said it would be 31 days. April only has 30 days, but in this case, the date is May 19th. That's the city's position.
Okay, and the board's position is that it would be the date that he responded, and so the board is going to deny your request, and we're going to hear the appeal.
Mr. Chairman, this is Patty. If you could make that as a motion to be included in the resolution, please. Thank you.
Okay, so motion to deny the appeal by the city that is being untimely, and that we will hear the appeal. Moved?
So moved.
Moved by Mr. Dank.
Second.
Second by Ms. Lipscomb.
Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes.
Ms. Lipscomb?
Yes.
Okay, Mr. Warren, go ahead and proceed.
Thank you. Thank you all for your time and consideration here. So as I stated in my appeal, in my original, we have good plans for this property. Unfortunately, the money I was making at the time I purchased that property. I'm not I'm not presently making, but I am kind of recovering from that gap in time where I was working in consulting as a partner at a top 10 consulting firm. And I stepped away to launch my own practice, and I just recently actually launched, and now I'm starting to win engagements and clients and earn the revenue needed to make these types of repairs. And my commitment to the city of Cleveland is that if given the time, I would definitely have this done by Q2 of 2026. I do live out of state now, but I am Cleveland born and bred. My entire family still lives there. Grew up in Cuyahoga County, went to several schools across Cuyahoga County. So I'm not just some out of state investor who doesn't care about Cleveland, just looking for a quick buck. I do love my city. I'm still a Browns fan, still a Cavs fan. Everything about me is still Cleveland, even though I live out of state. I just thought I would put that in there, just so you don't make the assumption that I'm some random out of state guy who doesn't have any love for Cleveland.
Now, what is that hazardous conditions?
So there's a bulge on the face of the building.
Okay.
And I do agree that it needs to be addressed. I did get some quotes in, even prior to receiving that notice. I did already grab some quotes from various reputable people around the city, and it is my mission to move forward with that as soon as possible.
Okay, Mr. Vanover.
Mr. Chairman, I apologize if there was no photos submitted. We're having some resource issues here with Kimberly Ward still being off. But what this is showing is, if pulling up the Google photo, there's deteriorated masonry on the face of the building, and portions of the facade are coming off. And it's as a hazardous condition, we would, it doesn't feel like there's a plan of immediate attention. And we would ask that you, and the appellate admits that there's a bulge in the masonry. We would ask that you remand it back to the department and encourage the appellate to move quickly.
Okay. A motion is in order to deny more time and remand the property division of building and housing for any further action.
So move.
Moved by Mr. Bradley.
Second.
Second by Mr. Denk.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Mr. Warren, you will have to move quickly on this, and especially since it's a hazardous condition, to take care of that situation. Thank you.
Yes, sir. Thank you all.
Through the chair to Mr. Vanover.
Yes.
I am in receipt of a lot of photos. I'm having issues with my Microsoft account.
Okay.
Well, just have to do a little explaining, that's all. Okay. Next docket is building docket A 127-25, 3801 Clark Avenue.
Good morning.
Application and fees are in order. Notice of violation is exterior maintenance issued on April 24th for 2025. Appeal was received on May 21st, 2025, requesting for 1 year to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates and Dan Jacobson for the Department of Code, for the Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record?
Good morning. My name is Dina Leone, and I am an associate pastor at City Reach Church.
Okay, Ms. Leon, do you swear or affirm to tell the truth, the whole truth?
Yes, I do.
Okay, go ahead and proceed.
Okay, we have been in our building for a number of years. It was given to us, and we are aware that there's a lot of repairs needed, obviously, from the notice that we received. We are a very, very small church, and especially after COVID became even smaller. And so we have extremely limited resources, which is one of the main reasons some of these things are difficult for us. In addition to that, over the recent years, our senior pastor has developed significant physical health challenges. And in fact, he had to go into the hospital last week and is hoping to get into rehab for his physical needs this week sometime. So that adds to the difficulty. We really love the community and want to serve and do our best there. Everybody except the senior pastor is really, and even he is, we're working other jobs outside the church. And so it's not like we're not addressing things and we're taking salaries and that sort of thing. We have tried to make some of the smaller repairs and fixes. We've painted some things. We have someone there going weekly to clean up debris. Part of the challenge is our location is great being on the corner of Clark and 38th, but also it captures a lot of trash and debris that sort of blow right onto the property. So we are aware of that, but we do have someone that goes over at least weekly to clean that up. We've had some of the painting done. We're aware that one of the major things that needs to happen is the repair of the roof, which was not in great condition when we received the building. But we've had numerous quotes for that, and it's just a huge undertaking for a church of our size, our denomination, and the resources we have available. And so with that challenge and the timing and the winter months and all of that lining up, we're really in need of this extension so we can sort of address each of these as they come and make a plan to try to, raise some funds and access some resources and some skilled labor. We don't have that kind of skilled labor even within our congregation, or we would definitely be asking folks for that as well. So we are asking for this extension and appreciate you considering it.
Okay, Mr. Vanover.
Mr. Chairman, what is this is pretty substantial and it doesn't sound like there's a lot of resources to complete. What is the actual request?
It was 1 year.
How much time?
1 year, I believe. Has that changed, Ms. Leon?
No, that's correct.
So she's looking for 1 year.
Mr. Chairman, as you know, that we will object to a year. But do we, is there an expectation that there will be resources and opportunity within a 180-day period if we grant 180 days?
We are certainly looking to access resources and receive help from people and our community. So we're reaching out and trying to get those resources and laborers.
Mr. Chairman, again, we don't, a year is too long. If there's an expectation they can get it done in 180 days, then we won't object, but I'm cautious.
Okay, well, so we're going to ask you to do your due diligence for sure and reach out, see what you can do. And we'll give you the 6 months, 180 days. That'd be May 19th, 2026 to abate the violations.
Okay, thank you so much.
Motion?
So moved.
Moved by Mr. Dink.
Second.
Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, you'll get a notice within 2 weeks. Thank you.
Thank you.
Okay, building docket A 168-25 3342 East 119th Street.
Application and fees are in order. Notice of violation has hazardous conditions, and interior and exterior maintenance. One moment, Mr. Chairman. My apologies. The information on the slide is incorrect. The notice of violations is exterior maintenance, issued on June 2nd of 2025. Appeal was received on July 2nd, 2025, requesting for 30 days to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Dan Jacobs, and Russ Gates, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record?
Yes, I am Eddie Burge, pastor of Covenant Community Church.
Okay, Mr. Burge, you swear or affirm to tell the truth, the whole truth?
Yes, sir.
Okay, go ahead and proceed.
Yes, we received the violations around the building. Due to, honestly, we have some of them taken care of, a lot of them that was taken care of. The gutters are back up. We had a few cracks in the foundation of the building due to a lot of accidents right there on the corner, but we were blessed with the city communicating with them. They put a rail up kind of right in front of the church. Multiple accidents right there, right on the corner. I'm right on the corner. So they did put a guard up now, so that will help with a lot of those accidents from from being hit with the church. But we did repair majority of them have been kind of repaired. Only one I'm focusing on is the dumpster, which I need some more clarity on. The dumpster is behind the church building. I do have a gate across the street in the parking lot. But I was looking, I don't know clearly what I had to do. Can I move it over to the gate I have for vans? But I no longer had a van, so I can use that gate for the dumpster. If that's the reason, I wasn't clear about what was the problem with that, because that dumpster been here since the foundation of the building was built. So I didn't know, I really didn't understand that one. What do we have to do? So if I can get some clarity on that. But the gutters have been put back up. The foundation has been sealed. I'm going to do better. We're putting together a project now to for the next summer, trying to just remodel around there, get it painted and fix it up better. But I did fix the cracks, had the cracks and seals that were damaged. The mortar put back in, fixed up. So as of now, I took pictures and sent the pictures in, emailed the pictures in. So just clarity on the dumpster area. That's where I'm at now with the dumpster area, trying to figure out what to do with that.
Okay. You were looking for 30 days, is that correct?
Yes, sir.
Okay. Mr. Vanover.
So, Mr. Chairman, there is a permit in place to establish this use and for work on the property. We don't object to 30 days.
He had a question, something to do with the dumpster, was it?
Yes, sir. That was one of the hits. The dumpster is like behind the building, which had been there since we've been up 17, 20 years now, and it's been right there in the same spot. It's behind the actual church, and it's sitting in a neat spot. So I don't know. And they were saying something about I got to get a fence or guard. So if we could be clear on that part for me, because I do have a fence across my parking lot across from the church that I could have it moved over, I guess, in there, but I don't know. I don't know if that's what they're asking.
Okay.
Mr. Chairman, based on the Google photos, It appears that there is a red fence that is in deteriorated condition and falling. The code says that you have to screen, if you can see the dumpster from either of the streets, then you have to screen it in. So however that gets accomplished, it needs to be screened in.
Okay, that's your answer, Mr. Burge. So you have to screen it in so it can't be visible from the street. Okay. And you can work with your inspector on that, but we're going to give you your 30 days, December 19th, 2025 to abate the violations. Okay?
December 19th, you said, sir?
Yes. Yes.
Okay. All right. And you said I could talk to my inspector and get more clarity on that.
Sure. Absolutely.
Thank you so much, sir.
Okay. Motion?
So move.
Moved by Mr. Bradley.
Second. Second.
Second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Notice to be sent out within 2 weeks. Thank you.
Thank you.
Next docket, building docket A 169-25, 1277 Hamilton Avenue.
Application and fees are in order. Notice of violation is failure to register. Issued on June 5th, 2025. Appeal was received on July 2nd, 2025, requesting for 120 days to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobs for the Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see Jeffrey Malik in the participants panel, nor is that person present this morning in room 516.
Mr. Vanover, do you swear?
14, sorry.
Truth?
I do.
Okay, Mr. Gates.
Through the chair to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Gates, no.
Through the chair to Ms. Davis, have you received any form of communication, an email, voice message, or anything delivered to you on behalf of this appellant and/or docket?
Through the chair to Mr. Gates, no.
To the chair, the due process requirement of notice has been given to this appellant. The board can proceed with the hearing and its ruling.
Okay, thank you. Mr. Vanover.
Mr. Chairman, it appears that the garage registration for this property has been completed. And they are in compliance.
Okay, so we'll give to today's date, November 19th, to abate the violation. Motion.
So move.
Moved by Mr. Dank.
Second.
Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Notice will be sent out within 2 weeks. Next docket is building docket A 283-25, 1132 East 105th Street.
Application and fees are in order. Notice of violation is condemnation of the main structure. Issued on October 28, 2025. Appeal was received November 14, 2025. Applicant did not give time specific. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates and Dan Jacobs, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and a representative please state your first and last name and your relationship to the property for the record?
Good morning. My name is Roland Jarvis, attorney at law. I'm representing Ms. Adria Hill, who I understand is present.
Okay, will you be the only one giving testimony?
I want to confirm that my client is present. I can't see her in the room.
Okay,
And I will not be giving testimony. She will.
okay. Oh, she will be giving a testimony, okay.
Is she in the room?
Good morning.
Yes.
All
Okay,
right.
good morning. This is Adria Hill. I'm the owner of the parcel located at 1132 East 105th, parcel number 109-025.
Okay, Ms. Hill and Mr. Jarvis, in case he does any speaking further, do you swear or affirm to tell the truth, the whole truth?
Yes.
Yes.
Okay, you can proceed. Go ahead.
Well, we have a petition that was filed, and the reasons for the filing are outlined therein. Do you have a copy of it in front of you?
I have, the only thing that I'm seeing here is there's condemnation of the main structure.
Okay, well, in our appeal of the decision, we make a reference to the adjudication order.
Okay, now, Ms. Davis, do we have such, is that in this? Is this an adjudication order?
Through the chair to the attorney, when did you submit those things?
No, these aren't things that we submitted. These are things that were received by my client from the city.
Through the chair to the attorney, the only thing that we are in receipt of from the client is the application, a copy of the condemnation notice and permits that was applied for. We did not receive an adjudication order.
Well, who issues the adjudication order? I have a copy of a letter. I have a copy of a letter dated November 6, 2025 from the Director of Building and Housing.
I don't know, maybe
City of Cleveland.
Mr. Vanover might be able to clarify something.
Mr. Chairman, the applicant came in to file an appeal on the condemnation of the main structure. If the applicant came in to file an appeal on the adjudication order, this would be on the agenda as an adjudication order and not as a building violation. We are not in receipt of the adjudication order. It is up to the applicant to bring that document into the board for consideration, sir.
Okay. All right, then. Well, then, Mr. Chair, I will call my client to testify and present the documents that we have. Thank you.
Okay, thank you.
Ms. Hill?
Yes.
Please proceed.
Yes.
Okay, Ms. Hill, go ahead.
Okay. Okay, so the first exhibit or document that I have is the appeal document.
It's identified as Exhibit A?
Yes, Exhibit A. That's the appeal document.
The application. So this is
Yes.
simply the front page of the appeal
That's correct.
application.
I'm sorry. Oh, okay. Okay.
Okay,
Exhibit
so,
B?
yeah, we have this, the building is in condemnation, so we're wanting to know, basically, when you can get it out of condemnation and how long.
Well, with permission, sir, I'd like to proceed. Ms. Hill, would you present Exhibit B?
Exhibit B is the property status and condition, the property record and visual evidence. This is a picture taken from the Cuyahoga County Auditor's website documenting that the property's condition prior to demolition shows a new roof, a dumpster, and rehab materials.
Okay, Exhibit C.
Exhibit C is the delayed, is the mailing evidence, mailing envelope postmarked October the 31st. Welcome. And exhibit, that's exhibit C, C1 and C2. Exhibit 3, C3 through C7 is the notice of enclosure, which is the condemnation violation notice and demolition order. This document is unsigned, unserved, and not posted on, and was not posted on the property as the demolition had already occurred.
What is the date of that document, Ms. Hill?
The date of this document is October the 30th.
Thank you. Exhibit D.
Exhibit D is a certification of proposed demolition. The document certifying that the demolition, certifying the demolition, which is unsigned and lacks the name of the authorizing director.
Is there a date? Is there a date on that document?
The date on this document is November the 6th of 2025.
Is it signed?
It is not.
Exhibit E.
Exhibit E. I have E1 and E2. Exhibit E1 is the building permit for 1132 East 105th Street, permit number B 25036-820, permit for the demolished undamaged parcel. Exhibit E2 is the okay, and then this permit, it shows that it was on the behalf of Idrea Hill that was not authorized by me. Exhibit 2 on E2 is a building permit for 1124 East 105th Street, the permit number B25036-822. And this permit, this is the permit for the parcel that was actually on fire. So the numerical sequence suggests that the property located at 1132 East 105th Street was pulled and processed before 1124 East 105th, which is the building that was actually on fire.
And those permits were pulled by who?
These permits were pulled by Brian Ballman, B&B Wrecking and Excavating.
And these are permits for what?
These are permits for demolition.
Okay, and so in terms of your opportunity to abate any damage to your property,
Excuse me.
when did you receive that?
Mr. Chair?
Yes.
All right. The city would like a chance to look at these documents before hearing any kind of argument in respect to them. So I wasn't sure where the attorney was going with that, but I don't have those documents, so
Through the chair, we're in the process of making copies of this, so to both the parties, give us an opportunity to make copies. Yeah, we'll make copies,
I'd like to get all the exhibits together and then.
Well, when we're done, you'll have all the exhibits.
An additional.
Yes, but we would like to look at them while you're making the argument on
When
them.
we're done, you'll have all the exhibits, sir.
Oh, wait, hold on.
Ms. Hill, would you proceed?
Excuse me, please acknowledge the chairman before you speak. Speak through the chair, not to each other. Thank you.
Ms. Hill, will you proceed with Exhibit F?
You're submitting them to the regarding. Okay, that's fine.
Are we on F? What is going on?
I'm trying to get my client to complete her testimony. She's being interrupted and interfered with.
We are on Exhibit 1 and Exhibit 2, and these are the demolition permits for 1132 East 105th Street, at 1124 East 105th Street.
That's E1 and E2.
E1 and E2, that's correct.
These were permits that were pulled by B&B Construction or Demolition Wrecking?
That is correct. Brian J. Baldwin, B&B Wrecking and Excavating.
Did you contact them to ask them to be present for this hearing?
They were asked to be present for this hearing.
And what was the response?
The response from Mr. Baldwin was that he had a meeting. I emailed him back and requested that he send someone in his stead. He was also sent the meeting information so that if he was not, him or his representative was not able to appear in person, then they can appear by logging on WebEx or calling.
Okay, you did not make a copy of that email, but we would ask that the chair take notice that the testimony is sworn to and under oath.
Yes, it is.
Would you proceed to the Exhibit F, Ms. Hill?
Exhibit F is a copy of 1132 East 105th Street, parcel number 109090025. This is a photograph after the fire was put out, showing that the building is still standing undamaged by the fire prior to the demolition.
And that, to your knowledge, that picture was retrieved by whom and when did you receive it?
That was retrieved by my husband. He forwarded the copy over to me.
And do you remember the date that you received that, or that picture was taken?
The picture was taken the 27th, October 27th, 2025.
And to your knowledge, when did you first go to the scene and try to at least secure the property?
When I went to the property, it was gone. That was on 11/27.
What do you mean it was gone?
It was not. It was demolished. Demo had already taken place.
You mean your building was demolished? It was destroyed?
Mr. Chair?
Yes.
Mr. Chair?
Yeah, yes. Is that Mr. Gates?
Yes, Mr. Chair. You can disregard that.
Okay. All right, go ahead, proceed.
And so after you went and you verified that your building was demolished, that was the 27th of October?
That is correct.
And what did you do to find out what you're supposed to do about your building? What did
My
you
husband,
do?
I went and filed, I hired an attorney.
And you got prepared to at least try to abate or do whatever it is you had a right to do according to your due process rights?
That is correct.
Okay. All right, so those are our exhibits, and that would be the testimony. We would open it up for any cross-examination if you wish.
Okay. Who's going to be taking this on, Mr. Gates or Mr. Vanover?
In terms of the,
we're in the process of making copies as well for Mr. Gates.
yeah, if we could just hold for a moment to get the exhibits.
Sure.
Thank you, Mr. Chair. Yes, and Mr. Chair, the city would like to enter an exhibit as well. I sent it over by email this morning, but it's, I won't get them a copy, but it's the fire report. It's the report from the Division of Fire of this whole demolition.
Well, can you be more specific? I don't have a copy of it. What's the date of it? Who signed it? And what does it say?
We're gonna get that over to you, but I mean, I can go through it if
You
you
have it in
like.
front of you, sir. I don't have it. Read it.
You know what? I'm just trying to proceed here. Okay, so I'm willing to do that, but you know.
Again, I'm asking everyone who's giving testimony to please speak through the chair, address the chair first.
Through the chair, to the appellant's counsel. Prior to today's hearing, we had no notice that the appellant was represented by counsel. So we
What difference
apologize.
does that make? What difference does that make?
Through the chair, please, counsel.
Okay, so
Thank you. So the prior report, it's an incident report that was.
So we're gonna give it to her then.
It's been handed over to the appellants, and it's 12 pages long. It basically.
Does it have a date?
Well, October 27th, there's several notes within the report. So most of the notes of the incident report are from October 27th, which was the day of the fire, and the day that the fire department went out there. I don't mind if this can be emailed to him or put up on the screen so that he can look at it. It's no problem.
Mr. Gates, I don't think we're getting anything on the screen today the way it looks. So there has to be things that will have to be sent. But I don't know if we can continue with this because we're kind of lacking here in I don't know how this testimony is going back and forth. So I don't know if it has to be rescheduled to get both parties to understand what happened here. And
Mr. Chair?
Yes.
If the appellant could just make clear what are you actually appealing? Are they appealing they did not get notice? Or are they appealing that it was not torn down into law? Because we're prepared to argue on both of those fronts. So what are you here for today? It was a fire. It was a huge fire that I believe there were 60 firemen that went out to the incident, and the city tore it down according to law. And so we're prepared to talk about that. We have Mr. Chief Building Official Vanover can testify. He was at the scene, and you can give testimony to that effect. So if you could just state what you're appealing.
What do you mean? What are we appealing?
Yeah.
Where's the building? Where's the building?
So what is your argument then, that it was demolished?
Where is the building?
Through the chair to the attorney, it's demolished.
Yeah. I think he understands that. He's wondering why it was demolished, when it was demolished.
Okay.
And I think they wanted the opportunity to abate the violations. And I think that's what he's saying, that they weren't given that opportunity, and it got demolished in the meantime. Did I sum that up okay, Mr. Jarvis?
Yes, sir.
Okay.
Okay, thank you. So to that point, this was an emergency, and under the authority of the Cleveland Codified Ordinance 3103.09J, in cases of emergency, the city, through the chief building official, can demolish a structure if he deems it's an emergency. There is no requirement that notice be given to the owner, which is also pretty much a common sense type of situation. I'm willing to put Chief Vanover as a witness, inform him as a witness to indicate that he was there and he did approve of the demolition. This board has no authority to reverse the emergency decision that was made by the chief building official. So that is our argument, and if you would like Mr. Vanover to provide testimony to that effect, we can do that. As I indicated as well, that notice is not required to be given to the prior to demolishing a structure when it's an emergency. It's my understanding that the streets were closed off. As I said, it was There's 60 firemen at the location, so the city stands by its decision, and if you'd like to get a testimony from Mr. Vanover.
We will. Mr. Vanover.
Mr. Chairman, this was a fire that was began in the early hours of October 27th. I believe it was labeled as a 222 fire with multiple fire men and fire members and apparatus responding. The building, the main fire was in 1124 East 105th Street. And this is this building is adjacent on the Charlie side of that. 1124 is the building before us today at 1132. When I was called by the Assistant Chief Schlommer that morning to attend because they had multiple collapses, the hazardous conditions. They had East 105th Street blocked and they needed to release the street, but as indicated in the report and in the communication on the scene with Assistant Chief Schlommer, they were not willing to release East 105th Street to reopen until the structure was demolished and made safe. My observations to the building at 1132 were the same as Chief Schlommer's, in that it was extremely exposed from what is the north side of the building, known as the Bravo side. There was evidence of the roof collapse, parapet bricks had fallen and displaced. So this building that we're speaking of, 1132, along with 1124, were in such disrepair after the fire and in such condition that they needed to be torn down for public safety. At that point, I made a phone call to B&B Wrecking. They are our emergency response team. At the request of the Assistant Chief, they came to the scene with their apparatus and raised the structures to where they were safe and they could reopen the street. This was done as an emergency, and all of the notices that were sent and all of the documents provided were all done post-demolition, as is typical during an emergency demolition.
Okay. Mr. Jarvis, you care to comment after that?
What I'm trying to understand, what, when, and where he was to make these observations. I need a timeline. My understanding is that you were at the premises of the fire, sir?
Well, through the chair, Mr.
Through the chair. Everything's through the chair.
Yeah, okay.
All my questions are through the chair.
Okay.
Mr. Chairman, yes, I was. I was on the scene with Assistant Chief Schlommer. At approximately, I was there between 8:30 and 9:30 that morning.
And your focus was on the whole block. Is that correct?
Through the chair, yes. My responsibility was.
Mr. Chairman, this is Patty. I'm sorry, the attorney, that this is how it normally goes. I don't know why you're trying, I don't know, are you chastising the person? He's testifying under Robert's rules. Everything goes through the chair. That's the process. The board said that in its preamble. It uses the Robert's rules of order. So he's answering through the chair. That's the normal process. That's his usual answer.
Good.
Right. And you've been he's been giving you the information that you're asking. Right. Okay. You asked if it was for that whole block and he said yes. You asked.
No, I want, Mr. Chair.
Yes.
I'm trying to get testimony that I may need for an appeal.
I got it.
So I'm trying to figure out who's testifying here.
Is
it Ms. Davis? Is it you? Or is it Hanover or Vanover?
It's Mr. Vanover. Mr. Vanover is the one that you were asking the questions of. He's the one that's giving you responses.
Okay, so Mr. Vanover, he's under oath.
Yes, absolutely.
Okay, all right, well, through the chair, what record do you have? Did you take pictures of what you saw and made your determination of a need to demolish my client's building?
Mr. Chairman, to the
Mr.
attorney, I was on scene to evaluate the entire block. We have provided photographs of the scene. There are multiple photographs from Cleveland Fire, from the Cleveland Fire Investigation Unit, as well as the firefighters on the scene, Mr. Chairman.
Okay.
Mr. Chair, may I ask the witness a question?
Yes, go ahead.
Mr. Chair, I
Hold
have
on.
a few questions here.
Okay, but
I don't know why I'm being interrupted. I'm not trying to chastise anyone. I'm trying to ask questions, sir.
Mr. Chairman, I
That's all
was
I'm trying to do.
providing testimony before cross-examination that never got completed. But, and to that point,
I'm sorry.
Mr. Chairman, yes, I was there to evaluate the conditions of the structure and as to engage the demolition contractor if need be. I made the determination that it was necessary to raise the structure for the safety of the occupants and the vehicle and pedestrians on East 105th Street.
Okay, Mr. Jarvis.
Did you take, through the chair, I asked you, let him finish his direct testimony, Mr. Chair, because I don't want to chastise anyone. I've heard what he just said, Mr. Chair, I heard twice. If he wants to repeat that, that's fine.
No, do you have the information you need, or are you looking for, you have more
I don't have,
questions?
Mr. Chair, I don't have the information that I need. I'm being interrupted.
Mr. Chair, this is Russ Gates with this city. So I had thought we were doing direct testimony, and then it kind of got interrupted and we went to cross-examination. So it's kind of like a back and forth, but I just had one or two more questions for the witness. If I could ask those now, or if you'd like me to wait until after the other attorney goes, however the chair would like to proceed.
Oh, Mr. Chair, I defer. I want him to, Mr. Chair, I want him to complete his direct testimony. If he has pictures from this witness that he wants to present, then I want to know that. I shouldn't have to ask this gentleman on cross-examination what the basis of his decision to demolish my client's property was.
For the chair, this is Executive Secretary Carmela Davis. I am in receipt of pictures submitted by Chief Building Official Tom Vanover. I am experiencing some technical difficulties. If you can email me or submit a public records request, I can get that information over to you.
Okay.
Through the chair, my client's already done that, and it was a nullity. Ms. Hill is right there. She can testify to it.
Mr. Chairman, this is Patty. If Ms. Hill could give us the attorney's email, we can make sure he gets that information. Or we can forward it to the photos to you have an email on record?
Through the chair, yes, I have an email on record for the applicant. I'm sorry, I did not receive a records request asked for anything submitted by the Department of Building and Housing. My apologies if that is missed. I am having technical issues with my Microsoft account.
So, Mr. Chairman, anything that was submitted to Ms. Davis on behalf of the department, she can forward to the email on file with the board, and that can be shared with the attorney.
Okay.
Well, Mr. Chair, then this matter is premature. I'm going to ask that we continue this matter to another date so that the information exchange can happen and we can have clarity, because the last thing that I want is to be accused of belittling, berating, or chastising anyone in these proceedings.
Yeah, you have said that quite a few times, so I got that. Mr. Gates.
Okay, thank you.
Mr. Chair, thank you. I appreciate that. Just a couple of things. First, the appeal that we received is that the defendant in the appeal statements said that they did not that notice was not provided. So technically, I think that's why we're here today. But we can and have already established the other issue, which is, was it properly demolished? And the city's contention is that it was. I don't believe any further evidence or review of any reports is going to change the fact that the chief building official was on site in consultation with the fire division of fire, and he decided it needed to come down. So unless this board is prepared to overrule the decision that Mr. Vanover made on site on the morning of October 27th, there is no need to continue it on the question of the demolition. On the question of notice, and just on a couple other matters, I would like to continue with my direct examination of Mr. Vanover, if I can do that.
You can, go ahead.
Thank you.
Through the chair, this is Vishnu. Given the technical difficulties our executive secretary experienced and the request, I'm not sure if this is a formal request by the attorney, but Mr. Jarvis calling this premature. Is the board in a position to consider continuing the matter so the proper exchange of documents and pictures and our technical difficulties are resolved here? To just putting that out there for your consideration. Thank you.
Right. Well, okay.
And that is my request, Mr. Chair. I mean, the idea that they can demolish a property that we feel it was intact on an emergency basis is bogus, and we intend to challenge it. And this is our first opportunity to do so. My client should have had notice and an opportunity to abate whatever damage that this man claims existed before they demolished their property. There, and he hasn't articulated any emergency that warranted what they did to my client's property.
Mr. Chair, an opportunity to respond.
Go ahead, Mr. Gates.
We've already been over this. The question before the board, which can be taken up today, is are you prepared to overrule the decision of the chief building official on site at an emergency and say that it was an improper decision? I think the board can make that call today. I don't think there's a need to rehash this and do this all again in 2 weeks from now. I'd also like to go over the notice and just ask the witness about that, so we can just cover that as well.
What? Oh, you're talking about notice too?
Yeah, I'd just like to finish questioning Mr. Vanover if the chair would allow it.
Through the chair, the applicant's witness want to make a statement, but I don't believe he was sworn in.
Which applicant?
Her
husband.
Let's see.
On the table right now. It's up to the chair. Let's just stop.
Is you saying Miss Hill?
Mr.
You have someone else there?
Yeah, my husband is in attendance, Raphael Carter.
Well, Mr. Through the chair, that is the reason we're asking for a postponement. I have not prepped this individual. I know that he was identified by my client. I don't know what he's going to testify to. And for now, I would suggest that we delay his testimony, gather the information from the city regarding their emergency basis for demolishing the property, and present as well the individual responsible for demolishing the property, B&B Wrecking. We need a full opportunity to be heard on this matter, including Mr. Hill or the husband of my client.
Okay, well, I think it's pretty simple for this board, and I can talk to our members of the board on this for a second, but that what's before us here is the chief building inspector making a decision based upon an emergency situation, along with fire, and looking over the situation that needed to be demolished. And so that's kind of what's before us here. The other notices and all the different things, I think, can be sent to Mr. Jarvis. So he has all that information and he can proceed on whichever way that he wants to go with it. So to the board, if you have any questions of me, Mr. Dank.
I have one confusion going back to the beginning of testimony. I understood the appellant to say that there were demolition permits outstanding at the time before the fire. Is that my clear understanding, or am I wrong in that?
No, you're mistaken. You're mistaken. The demolitions were pulled by B&B Wrecking on November 11th, 2025, months after they demolished my client's property.
I understand.
Okay. All right. Ms. Lipscomb.
Yeah, I have a question as well. So if the city issued the notice of violation condemnation of the main structure on October 28th, and it was received, when was the building actually demolished?
On the 27th.
It was demolished on the 27th, but the notice of violation was issued on the 28th. Is that correct?
And that wasn't received until November 1st.
I'm sorry.
That's
Through
correct.
the chair, I'm asking Ms. Davis.
Yeah, Ms.
The
Davis.
chair to Ms. Lipscomb. The violation notice as V as in Victor 250035506. The issue date is 10/28/2025.
Mr. Chair.
That is the condemnation of the main structure.
Okay.
Sorry.
Are you done, Ms. Lipscomb?
Well, I guess I have a question for Mr. Vanover right now. Is it typical to issue a condemnation of the main structure after the main structure has actually been demolished by the city? I don't understand that process.
Mr. Chairman, to Ms. Lipscomb, when the demolition is conducted on an emergency basis for the health, welfare, and safety of the surroundings and of the street, yes, the notice of violation is issued. It's issued for post deprivation purposes to complete due process. But as Mr. Gates has already mentioned, we also we have the emergency authority for the matters of life safety, health, and welfare to act in an emergency to abate a extremely hazardous condition.
So that's kind of what's before us.
I understand. It just seems odd. It seems odd that you're able to appeal.
Yeah.
It's just, yeah.
I
Okay,
got you.
I understand.
There is, Mr. Chairman. In the interest of due process, in light of our technical difficulties today, would there be benefit to receiving the materials that have been discussed, the photographs and some of the other information that has talked about being exchanged, so that this board can make a fully informed and confident ruling, and then the appellant can proceed from that point? Is that a reasonable course of events?
I think Mr. Jarvis would love that, but I would have to say that you want to have a
that's my request. Mr. Chair, that is my request, Mr. Chair. You're absolutely right.
Mr. Chair.
Yeah, due process requires that.
Yes, I get that. I guess I'm hung up a little bit on the emergency situation here. Mr. Gates, you had something to say.
Thank you, Mr. Chair. If I could ask the witness, as I was trying to complete the direct testimony, if I could just ask him a couple more clarifying questions about the notice process that we're discussing here.
Yes.
All right, thank you, Mr. Chairman. So, Mr. Vanover, if you could just walk us through the process of when there's an emergency. So, in this instance, you were called out to the site and it was an emergency, correct?
Correct.
Right. And you have stated already that it was, in your opinion, you decided that the building needed to come down, correct?
Yes, based on the condition of the structure and communications with the assistant chief of fire on the scene.
Okay, so this was an emergency demolition under the authority that you have, as we indicated, 3103.09J, cases of emergency, correct?
Correct.
When that takes place, afterwards, what do you do? What paperwork is sent out to the owner? What forms do you fill out to make a record and notify the owner in these types of situations? Let me be more clear. Does the city then, as a matter of standard procedure, issue a notice to the owner?
Yes, as a matter of standard procedure, there is a notice of violation and a demolition order issued to the owner for the purposes of, as stated, post deprivation hearing and due process.
Okay, and that was done in this case, is that correct?
That is correct.
Did you also sign a form after the fact regarding your decision to demolish the structure because it was an emergency?
There's a form that is provided to the Bureau of Demolition for the purposes of contracting and facilitating
Yes.
the demolition.
Necessarily, it's done after the fact, correct?
Correct.
And you did that in this case?
That is correct.
Would it be accurate to say you did that on November 3rd?
Yes.
Okay.
That is correct.
Thank you. To the chair, it's the city's position that the notice requirements that the
Well,
city.
can I cross-examine? Can I cross-examine on that examination before he closes, Mr. Chair?
Yeah.
I don't understand this.
I
What is going on here?
Go ahead. You want to ask him a question? Go ahead.
Well, where's the documentation that he's talking about that's dated November 3rd? I don't see it. Where's the notice?
Mr. Chair, that can be provided.
That's being provided.
Okay, well, when it's provided, then we can proceed, Mr. Chair.
Okay. And I think that the providing of this, I think, is something that will be necessary for you to proceed on, Mr. Jarvis. I think for us, the chief building inspector can, underneath an emergency basis, and he makes that determination to demolish a building because of safety and health. And so in many cases, I suppose it's something that's done, this might be done on the spot, but so there may not be the notification that you're looking for when this happens because it's sort of after the fact. But I think that he has that authority to do that. So I think that because of that, I really agree. You should have all that information, Mr. Jarvis. Whatever was sent, whatever they have, they should send that to you, okay? So that
no, they should send it to my client. It's not me.
Okay.
I'm representing the client, sir.
We'll send it to the client then. Make sure that all that information goes in to the client. But I still stand that the chief building inspector in an emergency situation has the right to proceed and to demolish. So
I agree. I agree with that, sir. But I take exception to the idea that you accept the testimony of someone that's biased on behalf of the city versus an expert who would have had the opportunity to inspect and determine the integrity of my client's structure and the need to have it demolished. You can't just give credence on an emergency that hasn't been established through this testimony or any other evidence of a situation requiring demolition of a structurally sound property that my client had.
I guess,
Mr. Chair,
we can argue over the term emergency, but I think emergency means that it's got to go right now because maybe things are being held up on the street. Maybe there's people in jeopardy. An emergency is an emergency. So therefore, having other people step in and give testimony, they have time for that. So I think he still has that authority to do that. So I'm going to put the motion out there, and maybe it doesn't fly, but that the city has the authority, the chief building inspector, to make that determination that emergency existed, and so therefore the building was demolished. And so that's the motion.
So moved.
Moved by Mr. Dank.
Second.
Second.
By Ms. Lipscomb.
Discussion?
Discussion.
This is Patty, Mr. Chairman.
Yes.
So is this board in its finding, is this board finding that the emergency actually existed and the city proved this emergency?
Yes.
Okay, I just want for clarification. Thank you.
Okay.
Do you
Okay.
want, and okay, discussion, should we?
It's up to,
it's
not sworn in. It's up to the chair.
Okay.
Okay. So it was seconded by Ms. Lipscomb. Call the vote.
Does he want it to, through the chair discussion, would you permit the appellant's husband to speak on the matter?
He needs to be sworn in.
He needs to be sworn in, and I know his attorney did not permit that, but he's raised up his hand again.
I think at this point, no. I think
Okay.
let's move on. We're going to move on with the vote.
Okay.
Mr. Dink,
Yes.
Mr. Bradley,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, a notice will be sent out within 2 weeks. Thank you. Next docket is housing docket A 122-25, 4270 Valley Road.
Application and fees are in order. Notice of violation is interior and exterior maintenance. Issued on April 10th of 2025. Appeal was received on May 6th of 2025, requesting for 60 days to complete abatement of the violation. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobs, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see the applicant in the participants panel, nor is that person present in room 514 this morning.
Okay, Mr. Vanover, do you swear or affirm to tell the truth, the whole truth? Probably muted.
I do, Mr. Chairman.
Okay, Mr. Gates.
Through the chair to Ms. Davis, did notice of today's hearing get returned to the board's file?
Through the chair to Mr. Gates, no.
Through the chair to Ms. Davis, have you received any form of communication, email, voice message, anything physically delivered to you on behalf of this appellant and/or docket?
Through the chair to Mr. Gates, due to some technical issues, I cannot affirm that to be true.
Okay. In light of that, I still, the appellant has not, oh, just one moment, please.
Right, I can't get into my emails.
We can reschedule it.
Okay. Okay, to the chair, a 2-week continuance is, city does not object to that.
Okay. Ms. Davis, you can make that happen?
Through the chair, yes, sir.
Okay, we'll move on. Next docket, housing docket A 124-25, 1310 West 76th Street.
Morning.
Application and fees are in order. Notice of violation is interior and exterior maintenance. Issued on April 23rd of 2025. Appeal was received May 19th, 2025, requesting for 6 months to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobs, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record?
Red button.
Yes.
Oh, okay, there it is. My name is David Fox. I'm the sole member of 1310 West 76th Street, LLC.
Okay, is that Fox?
Yes.
Okay. Mr. Fox, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay, go ahead and proceed.
So we bought this property during COVID. I'm a realtor investor and single family home developer in the city of Cleveland for the past 40 years. I've renovated and have built many properties within the city, mostly on the west side of Cleveland. So our intentions when we bought the property were to either renovate it or to tear it down and build new. We've made a decision that we're going to move forward and probably raise the house and build a new property. I do have pictures of its current condition. If the board wants to see, these pictures were taken yesterday. The siding is sound except for 2 locations on the house. It has a sound roof, sound foundation, and all the utilities inside are turned off. It actually has upgraded electrical throughout. But the highest and best use for this property is actually a 2 or 3 family, and that's what we've determined to do. We just need time. But here's renderings of what we're looking at building at the property, if you'd like to see.
Don't think we can see anything at this time, but we're taking your testimony. And how much time do you think you need?
I'm sure we're going to need a year to 18 months to have the new structure built. My last permit I pulled through the city of Cleveland took 4 months to get the permit approved. So,
okay, assuming you get the permit, how much time do you think you need?
I would think we're going to need a year to build the property.
Mr. Chairman, I'm sorry to interrupt. Mr.
No, go
Chairman, the violation notice before us is for is a condemnation of the main structure. Once that structure is raised, then that nuisance is abated. And so we would not object based on that determination. We would not object to 90 days to abate the violations by raising the structure.
Okay.
Through the chair, please.
Yes.
Okay. So I've contacted a demolition company. I'm actually getting quotes on now to raise the structure. I think we might need more than 90 days though.
Well, we can move it out to 120 days and hopefully you get it done.
We'll do our best.
Okay. So motion is in order for March 19th, 120 days, 2026 to abate the violations.
Move.
Okay, moved by Mr. Bradley,
Second.
second by Mr. Dank.
Oh, Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. No, okay, notice will be sent out to you within 2 weeks. Thank you.
Thank you.
Okay, housing docket A 126-25. 3892 West 36th Street.
Mr. Chairman, the slides don't match the docket.
Okay, let me see what you're looking at here. Notice of violation, exterior maintenance. We have interior exterior maintenance is what the violation is. It's going to be a Randy Cedino. It's 12625. Here we go. This is the right one. Thank you, Mr. Vanover. Okay, go ahead and read that one off then.
Oh, that's why I was confused. Okay. Application fees are in order. Notice of violation is interior and exterior maintenance issued on April 23rd of 2025. Appeal was received May 19th of 2025. Appellant was asking for 6 months to complete abatement of the violation. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record?
Good morning. My name is Randy Cedeno, and I am the owner of 3892 West 36th Street.
Okay, Mr. Cedeno, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay, go ahead and proceed.
Good morning. I'm asking for a 6-month extension. This property originally I purchased to move in with my family, but for a series of life-changing issues, I did not move into the property. Long story short, I rented it to an individual who destroyed the property, and I was unable to enter the property for some time. I ended up getting a civil protection order against this person. The person was removed from the property on the 23rd or 24th of April, which was the day prior to receiving the violation notices. I still need 6 months to be able to take care of the damages done to the property.
Okay, Mr. Vanover.
Mr. Chairman, for a rental property, 6 months is typically longer than we will provide. We don't object to more time, just a more modest amount of time.
I think in listening to his testimony, he's planning on moving in here. This isn't going to be a rental property. Is that correct? Or are you planning on renting it?
Right now, I'm not going to be moving back into, or I'm not going to be moving into that property. So it's going to become a rental property.
Okay.
However, the property wasn't move-in ready for my family specifically, but there was so much damage done to the property. I need extra time, and the legal process went a long time. And so I need to recover and be able to get some capital to put behind this project. I think 6 months will be sufficient for me to complete all the repairs.
Yeah, well, if we've seen pictures of this, how much it was trashed, it might make a difference. But all right, let's see. We'll give you the May 19th, 180 days, 2026 to abate the violation with no further extensions. Thank you.
So moved.
Okay, moved by Mr. Dank.
Second.
Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, notice to be sent out within 2 weeks.
Thank you so much.
Next docket, housing docket A, 128-25, 9201 Lacey Avenue.
Application fees are in order. Notice of violation is exterior maintenance issued on April 24th of 2025. Appeal was received May 22nd, 2025, requesting for 6 months to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates and Dan Jacobs, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see Mark Campbell in the participants panel, nor is that person present in room 514 this morning.
Thank you. Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay. Mr. Gates.
Yes, through the chair to Ms. Davis. Did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Gates, no.
Through the chair to Ms. Davis, have you received any form of communication, email, voice message, or anything physically delivered to you prior to the hearing today on behalf of this appellant?
Through the chair to Mr. Gates, due to my technical issues, I cannot affirm that we are in receipt of any email communications with this applicant.
Okay. Well, in that case, to be consistent with our previous appellants, then I guess we would ask for a 2-month or, excuse me, 2-week continuance.
Okay. Ms. Davis, can you make that happen?
Through the chair, yes, sir.
Okay. Then we're moving on. Next docket is Housing Docket A, 129-25 672 East 127th Street, and that one has been withdrawn. Next docket is Housing Docket A, 130-25 3356 West 95th Street.
Application and fees are in order. Notice of violation is exterior maintenance issued on April 22nd of 2025. Appeal was received on May 22nd of 2025, requesting for 90 days to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see the applicant in the participants panel, nor is that person present in room 514 this morning.
Mr. Vanover, do you swear or affirm to tell the truth, the whole truth? Probably muted.
I do.
Okay, Mr. Gates.
Thank you. To the chair, or through the chair, it's my understanding that the violation notice has been closed. I was wondering if we could ask, if I could ask Mr. Vanover to confirm that on the record.
Sure. Mr. Vanover.
Two, three, 5, 6. Yes, Mr. Chairman, it has been closed as of
Okay.
11/13.
Okay. Motion is in order to grant till November 19th, today's date, to abate the violations. Motion?
So moved.
Okay, moved by Mr. Bradley,
Second.
second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, notice to be sent out within 2 weeks. Housing docket A 131-259815 Westchester Avenue.
Application and fees are in order. Notice of violation is condemnation of the main structure issued on May 12th of 2025. Appeal was received May 22nd, 2025, requesting for 5 months to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see the applicant in the participants panel, nor is that person present in room 514 this morning.
Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Mr. Gates?
To the chair, due to the technical difficulties of confirming notice, we would ask for the 2-week continuance.
Okay, Ms. Davis, can you make that happen?
Yes, sir.
Okay. We'll move on to the next docket. Housing docket A 132-25 1789-1791 Randall Road.
Application and fees are in order. Notice of violation is exterior maintenance issued on April 25th of 2025. Appeal was received May 23rd, 2025, requesting for 2 years to complete abatement of the violation. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobson for Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record?
I'm Tim Rosenberger. I'm the owner.
Okay, you got a little echo going there, so you might have 2 devices on. Mr. Rosenberger, do you swear or affirm to tell the whole truth?
Yes, I do.
Okay, go ahead and proceed.
Well, I'm not really sure what to make of this violation. I wonder if it's for a different property. The house next to me is literally falling down. It's vacant. I'm not sure why I'm getting it. It included, among other things, okay, that is my house. It included, among other things, a thing about, like, tall plants. I don't have any yard, but my house goes from property line to property line. It's like tall plants in the rear. So, not sure what that was. I hired a preservationist to come look at the foundation. His opinion was I should do nothing with it. He said stripping the paint off of it would degrade the sandstone. Painting it had degraded the sandstone. He said, you should do nothing with this. You should not paint it. You should not strip it. Eventually it will weather naturally. That would be best. He said, if I need to actually, it's unclear to me from the statement of violation what needs to be done. If I actually need to change out the foundation, it's going to be like $100,000 of the house up on Jackson, put in different sandstones. I'm really hoping that's not what I need. I contacted the inspector as soon as I got the violation and heard nothing back, so I still don't really have clarity of what precisely they're asking for.
Okay. Mr. Vanover.
Mr. Chairman, these photos and others indicate that the exterior maintenance issues exist. The appeal statement said they wanted more time, but it appears that the applicant is also contesting some of the violations. We don't object to more time, but we, as a rule, we don't give time just simply for, due to funding.
Well, I need a much more precise guidance on what needs to be repaired. Among other things, it said like, repair a foundation. I'm not sure what that meant. Because I've done what the preservationists told me to do.
Well, Mr. Chairman, through the chair, you can see the deterioration of the sandstone foundation in this photograph and others, and it's clear also on the Google Earth photo that the sandstone needs to be repaired, replaced, or tuck pointed.
Through the chair, that is not clear. The preservationist has said you should leave it as is. It will naturally weather. It was a mistake to have painted it. It should not be painted. It should not be stripped. It should be left to naturally weather.
Mr. Chairman, we would need some to be provided that documentation stating such. I've never heard of such thing. At minimum, there's peeling paint, chipping paint, which is also, violation under the ordinances on the foundation. It was painted previously.
Okay, so that would have to be corrected.
Well, again, through the chair, the preservationist opinion was that it should be left to naturally weather. That painting it would degrade the sandstone further, and that stripping the paint off would also degrade the sandstone, so it should be left to natural weather.
Mr. Chair?
Yes.
This appeal was, it was made on May 15th. And the appellant is referencing preservationist expertise that we're not able to verify. And I would ask that the violations that were issued by the city be upheld, and the appellant has the opportunity to reach out to the inspector. And if the preservationist, convinces the inspector that perhaps some of the violations can be removed or abated in some other fashion, that's something that could be worked out with the inspector. But other than that, I believe the violations should be upheld.
I emailed and called the inspector at the number and address provided in May, and to date I've heard nothing. Gotten no email, gotten no phone call. I'm not sure how I'm supposed to be working with the inspector. They won't be in touch.
I think what the testimony that Mr. Gates was giving was that if you have some preservationist or someone that is an authority on this that can document it, and with his credentials, you can get with the inspector and either convince him that, all I need to do is maybe paint this or something, then that's fine. If the city agrees to it. So we're going to uphold the violation. And how much time do you think you need to do what you're doing? 2 years is unacceptable.
Respectfully, through the chair, I'm not sure how I would have my expert be in touch with the inspector when I can't get in touch with the inspector. Like, I've asked for clarification on a number of the violations, what precisely they mean. Things like, chipped paint. If it means chip paint on the porch, sure, I can paint the porch. If it means I have to repaint the whole house, which I just spent like $20,000 repainting a couple of years ago. I don't know what that means. Similarly, with the foundation thing, it says, repair the foundation. If it means slap a coat of paint on the foundation, that is not what the preservationist says is a good idea, but that can be done pretty easily. If I have to put the house up on jacks and replace sandstone blocks, it's going to be a much bigger problem. And I cannot get any clarity from the city on what precisely these violations are, because I've emailed, I've called, I'm sort of out of things to do.
To the chair.
Yes, Mr. Gates?
Or to the chair. The city will commit to definitely reaching out to the appellant and having the inspector contact him, within a few days to resolve that communication issue that he's talking about. And after that, we can go forward, as was mentioned by the chair, to go through the violations one by one. If he wants to bring in the preservationists to talk to the inspector, it can be resolved. But the city would ask that the violation notice be upheld. And I believe Mr. Vanderwer was okay with some time, or the board is okay with some time to, for the appellant to abate the violations.
So I would like, through the chair, I would like to request time through next summer to abate. If I'm going to be painting, I can't paint until summertime. So the paint can cure. And I'd like the option to request a further extension if, in fact, the city inspector really does want me to replace sandstone blocks. If that's going to be an unbelievable difficulty, and I sort of look around the neighborhood, and my sandstone looks like everyone else's, so I'm not sure why I'm being singled out.
Well, okay, because you're talking about, we're not sure which way this is gonna go. How about, we're gonna give you 6 months, 180 days to May 19th, 2026 to abate the violation. Motion?
So moved.
Moved by Mr. Bradley,
Second.
second by Mr. Denk.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, well, you'll get a notice within 2 weeks. Good luck. Thank you. Up next, housing docket A 165-25, 3856 West 23rd Street.
Application and fees are in order. Notice of violation is no permit issued on July 1st of 2025. Appeal was received on July 1st of 2025. Applicant did not specify how much time was needed to correct the notice of violation. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record?
Yes, this is Tyrone Taylor of the
Okay.
house.
Okay, and this is your house, right?
Yes,
Okay. Mr. Taylor, do you swear or affirm to tell the truth, the whole truth?
yes,
Okay, go ahead and proceed.
yes. Mr. Davis wrote me up a violation saying that I built a new garage. Well, actually, when I bought the house, it was actually a permit to board up the garage. So I actually put a new roof on the garage, but the way that he wrote up the violation, I couldn't go to pull the permit on the garage for the roof. But I actually put a new roof on it. But as me building a new garage, no. The way he wrote it up, like I built a whole new garage.
Okay. All right. Mr. Vanover.
Mr. Chairman, let's see, I have a notice of violation. Bear with me, please.
Excuse me, Mr. Chair.
Hold on just a minute.
Okay, all right.
We're waiting on Mr. Vanover.
Oh, yes, Mr. Chairman, looking at the notice of violation, it does say for the construction, the entire construction of the garage. And so I am, I'm looking to see how long this garage has been here. Bear with me, please. So, Mr. Chairman, it appears that the garage has been here since at least August of 22. However, there is a new roof and new siding on the garage that are all unpermitted.
Okay. So he just needs to apply for a permit, right? And explain exactly what he did. Is that correct, Mr. Van?
Correct, Mr. Chairman. However, it appears bear with me, please. Yeah, Mr. Chairman, this garage appears to have been here since '07. We would ask that the appellant needs to pull permits for the roof and the siding on the garage.
Okay. All right. So that's the ruling. You're going to need to show what you've done and pull the permits down for the city on the work that was done there. And then they'll get it inspected and you'll be all set. So motion is in order. We give you 30 days be enough time, you think, board, to draw something up and get the permits?
I think that sounds reasonable.
Okay, so we give you to December 19th, 30 days, 2025, to obtain the permits for the work that you performed. Motion?
So move.
Second.
Okay. Moved by Mr. Bradley, second by Mr. Denk.
There's two.
No.
Mr. Chairman,
Yes.
can we have a little clarification? When you say obtain permits, is that to have the physical permit in hand or to at least have it applied for in the system? I do get calls back from the applicants clarifying that if they have to physically have the permit in hand or at least have applied by that date.
Okay. Okay. I see what you're trying to say.
Mr. Chairman, we don't object to 90 days to have the permits in hand.
Okay, there you go. That'll take care of that. All right, so we'll redo that order. Motion for February 19th, 90 days, 2026, to abate the violation.
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Denk.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher,
Yes.
Ms. Lipscomb.
Yes.
Okay, notice will be sent out to you within 2 weeks. Thank you.
Thank you.
Okay, housing docket A, 166-25, 8023 Detroit Avenue.
Application and fees are in order.
An opportunity to speak about it on. I brought 9 additional tickets last night.
Hang on, please let them talk.
Application and fees are in order. This is a notice of violation of poor workmanship. Issued on June 11th of 2025. Appeal was received July 2nd of 2025. Applicant did not specify how much time they would need to correct the abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the contractor and the owner please state your first and last name and your relationship to the property for the record?
Yes, my name is, to the chair, my name is Andre Mann, contractor of 8023 Detroit Avenue.
Okay, thank you. And who else is on?
My name is Nicholas Cafanteris, to the chair, owner of 8023 Detroit Avenue.
Okay, both of you solemnly swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Okay, Now we got to say who's going to speak first. The owner?
I suppose I could. So I have here a record of payments to the new contractor, going back quite a few months, highlighted the Zelle payments, rectifying the exact work that was highlighted by the violation on 7/11/2025. I'd also like to note that I have evidence to the pay apps. There was pay app number 1 and pay app number 2, highlighting the exact work that is highlighted in the violations, indicating that they were paid for this work and they applied for payment for this work. It is also stated that this is total completed on these documents. It's page 4. 1, 2. Page 4 of the application shows that their second application was applied for this work that is in question. Thirdly, I'd like to state that there was a change order on the last page of this pay application, highlighting further work. And this change order was not included in the docket documents, which I'm not sure was intentional or not, but this change order pertains directly to much of the work that's in question. And once again, this last page is not part of the docket documents.
Did you want to speak to your presentation?
Sure. So there were quite a few windows that were not installed. And it turns out that those windows were ordered as the wrong size. Winter was coming and we had to replace them. It would take a great deal of time to get those windows reordered and a great deal of expense. It was also very expensive to reframe the openings we had to because winter was upon us. And so I had to hire a contractor to go ahead and replace all those windows. I had texted Andre Mann after we parted ways. I have a screenshot of this text, November. Let's see, what is it? November 9th, 2024 at 2:17 p.m., stating that all the windows that had not been installed with the wrong sizes. There was no response. There were several phone calls on that date. There was no response. Now, I understand that Andre Mann was terminated on August 30th after 5 weeks of not doing any work. After 2 weeks of having received the second payment of $24,000. He was terminated for those reasons, but I was expecting at least for him to address those windows. I had no response from him. Also, there was a great deal of water damage coming in through the back, which seeped through the framing and went all the way down to the basement. Those are the photos. Back balcony. That's a further photo taken from the interior of all the water damage that had ensued by July. And that's from under the basement. And that is still there because most of the house has been finished, but that is still visible and present. Next slide, please. Or is that full? Yes. So part of the comments by the inspector were issues with the LVL. There was an improper connection, rotted. So new windows were installed into rotted wood. They had to be taken out and reinstalled in several places. This happened in at least 3 windows. In total, in addition to those 3 windows, there were 8 other windows that were not installed. I had asked repeatedly during our time together to why those windows were installed. I did not find out that they were all the wrong sizes till way after. Okay, there was also issues with this LVL, which we had to fix. We had to add another, to the left there, some new wood for that opening. Next slide, please. Just a general showing of the sloppiness of the lap siding and some of the interior framing. All that has been replaced, everything. I'm not sure if there's new pictures here, but this is a very notable house on 8023 Detroit Avenue. It's a boon to the neighborhood. It has been a great improvement. Many eyes are upon it, and it is considered by some a landmark. This is how it looks now with the new contractor. As you can see, All of that siding is brand new. And most of the interior is very near completion. So I have records of payments. I have 4 proposals from Two Bald Guys Construction here as exhibits. I know it's a funny name, but they do very good work. Totaling $41,000. The bond does not even come close to covering the work that I've had to do to rectify these mistakes. I like Mr. Mann, and we had a good conversation, many times over the course of our work. But at the end of the day, I made payments, and I expected work to be done. I am a consumer that does not know construction, and I had to find all the mistakes later from someone that knew more about it. So I think that concludes everything that I have. I do have all these records that can be copied and presented. All the payments, the result payments, are highlighted here. I also have a copy of a check written from Prime Lending for further rectification of their work.
Mr. Chair.
Yes.
Through the chair to the owner, the additional paperwork that you have, can you provide that to Ms. Davis?
I provided it very late at 9:30 p.m.
You already provided it.
Yeah,
Okay.
that's why I wanted to come to make sure you guys had copies. I wasn't sure if Ms. Davis had received it, so I wanted to make a point of coming here today.
That's all. Thank you.
Yep.
Okay, so you're requesting more time to abate the violations, correct?
I'm requesting for them to the bond, that the bond is justified. Mr. Mann here is asking for an appeal for the bond. He's saying that I suppose he's saying it's unjustified for whatever his reasons may be. But I think that the bond is justified and the $25,000 is owed to me.
Okay. All right, we'll go to Mr. Mann.
Mr. Chairman,
Yes.
if I may interject here,
Yeah,
the board does not decide whether the bond is owed or not owed. This is a poor workmanship. We've just heard from the property owner. I would also like to reference the notice of violation itself, which states many of these things in it, and then of course provide the contractor who was specifically cited. He'll be able to present his there was a lot of information provided regarding payments and money owed. The Department of Building and Housing and this board does not, we do not have a bond process for, it is not a performance bond, it's a surety bond, only to be sure that the work that was performed to code, not to guarantee that the work promised gets completed.
Well, then you could tell that it was to code or not. Is that correct, Mr. Vanover?
Correct. And what was cited in the notice of violation were many instances of where it was not to code and where the work that was completed was done improperly.
Okay. So to that end, all right, as far as the contractor is concerned, our only issue in this is it giving the appellant more time to abate the violation?
No, Mr. Chairman, they're asking, the appellant is the contractor, and the contractor has been cited for poor workmanship and then has been removed from the project.
Okay.
So the city would ask that you uphold the notice of violation as properly issued. We will let the contractor speak. I assume that the contractor is going to provide information contrary, stating that there was no poor workmanship.
Okay. All right. So we'll hear from Mr. Mann now, correct?
Yes.
Okay. Go ahead and proceed.
Mr. Chair, on this project, we had several interruptions as far as, first of all, we had to apply to the landmark. And while we was applying for the landmark, we had to wait on the outside. And then we went to Cleveland Public Lumber to order materials for the outside because it was a special order. And as we was doing so, he kept changing orders and different things like that. Everything was not completed. And he also signed off on funding for the projects because he kept changing everything. I mean, every time we get started on something, he want to do something else. And then it just kept going. It was a snowball effect. And we never got a chance to complete anything. He dismissed me because he ran out of money, his contingency fund. And I complained to him about, you're running out of money, Nick. And he said, well, I got it covered. But to my defense, I never got a chance to complete anything. We kept jumping from project to project to project to project. The windows that was ordered, we had to frame in. We never had time to frame them in. The ones that we did install was installed correctly, but we just didn't frame them in completed. Wasn't anything completed on the house because we kept moving around from project to project. We went to a stairwell that he wanted, a special made stairwell, wasn't in the contract. So we had to go to the lender and asked for permission to do these things that he wanted and not things that was on the contract. Most of the things that was addressed was things that wasn't on the contract. So that's where I lie in not being able to perform my job correctly. And he dismissed me because of an argument with the consultant. I never had a chance to complete any of the work. I had my Amish crew there with the LVLs and everything. We asked the architect, and he gave us specific orders to do certain things, which I know that wasn't correct. And I called him back, and nothing happened. You know, so we had to order all kind of wood, all kind of different materials, and that would held the job up. The windows took almost 8 weeks. And then when they came out, we told them it was the wrong windows. So it wasn't on our behalf that some of the windows was wrong. Then they came back and gave us more windows. The LVL that was installed correctly, but he had contractors after me. You know, so I don't know what the pictures entail or not.
Let me ask you a question. Did you order the windows or did he order the windows?
The window company came out and measured.
That's a lie, Your Honor. The window company insisted that they measure the windows. They would not take responsibility. ABC Windows.
So when we measured the windows, excuse me, Mr. Chair.
Go ahead.
When we ordered the windows, they sent us the wrong size, as I said before.
Okay.
Then we came out again, and they sent us more windows. And some of the windows was not in the packet when they arrived. And we addressed that again. But if so, we still hadn't had time to install them. We had to frame most of the windows because they were special ordered windows, as you see on the picture, the exhibits, and same as the doors. Everything was special and everything was special order. Wasn't nothing standard in this house. So I haven't had a chance. Even the decking on the roof, we had to wait on the city to move the wires from hanging on the railing, so we couldn't install the railing to complete the back porch. So everything was a delay and not on our behalf. Everything was special order, so we had to wait.
Your Honor, may I speak again?
Yes, go ahead.
I'm not contending upon any work that did not happen. I'm contending upon what's written here as having been paid out. There was a payout for $59,000 in March. There was a payout for $24,000 in August. There's a list of percentages of work that was taking place on this document, and that is what I'm contending. Whether I changed my mind a million times or not is immaterial. I'm contending upon the work that was finished, that was applied for, and called as done on page 4. Total completed.
Mr. Chair, there was nothing in my orders that was total completion, except maybe the roof and the demolition.
Okay, so you didn't complete anything?
No, sir.
Okay, and
yet they were paid $84,000 and did not complete anything.
And the reason, Mr. Chair, the reason, like I said, there was no completion because everything was allocated towards other things that was special ordered by Mr. Nicholas.
This was not communicated to me. There were 5 weeks with no work.
Waiting on materials, Mr. Chair.
Not true.
Mr. Chairman, Mr. Chairman, I would like to again refer to the notice of violation that was produced upon inspection by the city of the building inspector that does identify areas of deficiency.
okay,
And I will read it into the record. Received an email that stated from the owner that stated they are going to change contractors. The home was gutted and some windows were installed and rear porch framing was completed without call for inspection. At time of inspection, roof was not approved. Porch posts not properly supported. Verify the first floor LVL was the correct size. Second floor turret not on the LVL bearing. Verify 2x8 beam in master bedroom. Tempered glass required at second floor bath. The exhaust required for the dryer. Improper notched joists at the master bath. Dining room floor joists cut improperly. 6 require support. 6 require support posts at the basement. Cut floor joists. Need header at the back door. Some windows were improperly sized for the opening. Repair crooked siding. The rear porch was holding water and improperly pitched. Secure the library window. So these are things, Mr. Chairman, that the inspector had identified. Improperly notched joists, improperly cut joists, non-bearing of supporting members. Those are indications of poor workmanship. We would ask that you uphold the notice and remand it back to the Department of Building and Housing.
Excuse me, Mr. Chair. That work wasn't done by me. That work was done after I was relieved. I haven't touched the basement except demolition, and the LVL we installed was proper. And I don't know what happened to everything. We had pictures of things that we touched. We didn't touch the things that were stated, and we didn't. The back porch we never completed.
If I may interject, the basement photo illustrates the water damage only, which poured from the second story on through due to the faulty back roof.
okay,
Mr. Chair, if I never had a chance to complete the back roof, how is it going to be completed? I went over after he relieved me. I went over and cleaned up everything, returned everything back to Mr. Nicholas. I did everything as I was told. He asked me to leave, and then he also had other contractors in after me. And then a year later, I received holding on my bond. I mean, wouldn't you expect someone to address things immediately and not a year later or months later?
It
I don't
took
know.
months.
Yeah,
It took months to get to the bottom of a lot of these problems, Chair, and that's the truth of it. In addition, there were some issues with the contractor. It was difficult, and it was a process. There was a time gap. It took time to rectify all these mistakes.
Mr. Chair.
Yes.
There was a contractor before me that declined his project because of the difficulties and the changes that he wanted the contractor to do. I came in and it was difficulties. We worked through them. We went through several houses before we wind up with this house. And after I was done, it was several more contractors that was on the job site that Cleveland Public Lumber said they returned materials that he had ordered through another contractor that refused to work on the house because of the difficulties and the changes.
Okay, Mr. Vanover, what was your recommendation?
Mr. Chairman, this is going to be a civil matter that goes on for some time, but we would ask specifically that you uphold the notice of violation as issued, as properly issued, and remand it back to the Department of Building and Housing.
I think that's all that we can do. So motion is in order to uphold the violation as properly issued and to remand the property back to Division and Building and Housing for any further action. Motion?
So moved.
Okay, moved by Mr. Dink.
Second.
Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher. Mr.
Yes.
Chairman, you
Yes.
have the contractor, he has his hands raised.
Okay.
Excuse me, Mr. Chair, does that still hold my bond for the city of Cleveland?
I can't answer that question. Okay. As far as the bond's concerned, I've already been told that, so that's out of my parameter.
Okay.
Okay, you'll have to take that up civilly. Thank you.
Thank you.
Would you like copies of these?
Okay, notice will be sent out within 2 weeks. The next docket is housing docket A 167-25, 12822 Marston Avenue.
I have them. Yeah.
Good morning, Mr. Chairman. Attorney Jeffrey McGaffick on behalf of Marston.
Application and fees are in order. Notice of violation is exterior maintenance issued on May 27, 2025. Appeal was received July 2nd of 2025. Applicant did not specify how much time was needed to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates and Dan Jacobs, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record?
I apologize. Again, Jeffrey McGaffick, attorney on behalf of Marston Duplex LLC.
Okay, Mr. McGaffick, do you swear or affirm to tell the truth, the truth?
I do.
Okay, go ahead and proceed.
Basically, Mr. Chairman, the owner has obtained estimates, has not commenced the work yet due primarily to financial situations. He's in the process of trying to sell off some properties to get the funding to complete the violation repairs. Respectfully requests a 60-day extension to complete these repairs.
Okay, for the repairs, yeah, we can give you time, but for sale or whatever, no. So I'm going to go over. Okay, I'm going to go over to Mr. Vanover.
Sorry, what is the request, Mr. Chairman?
60 days.
We don't object to 60 days.
Okay, motion is in order to grant till January 19th, 2026 to abate the violation. Motion?
So moved.
So moved.
Okay, moved by Mr. Dank, second by Mr. Bradley.
Mr. Dink,
Yes.
Mr. Bradley,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you, Mr.
Thank
McGafferty.
you, Mr. Chairman.
Okay. Next docket is housing docket A 170-25, 4201 East 144th Street.
Application and fees are in order. Notice of violation is condemnation of the garage issued on June 18th of 2025. Appeal was received on July 2nd of 2025, requesting for 9 months to 1 year to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobs, Division of Code Enforcement, Department of Law. Will the applicant or his and her attorney please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see the applicant in the participants panel, nor is that person present in room 514 this morning.
Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Mr. Gates?
Through the chair to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Gates, no.
Through the chair to Ms. Davis, have you received any form of communication, email, voice message, something physically delivered to you on behalf of this appellant?
Through the chair to Mr. Gates, I cannot affirm that I have not received email communications from this applicant due to some technical issues.
Okay, thank you. I thought maybe it was resolved. To the chair, the city would request a 2-week continuance.
Ms. Davis, can you make that happen?
Yes, sir.
Okay. We'll move on to the next docket. Housing docket A 195-25 9813 Lamontier Avenue.
Application fees are in order. Notice of violation is condemnation of the main structure issued on July 23rd, 2025. Appeal was received August 5th, 2025, requesting for 90 days to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record?
Aaron Lofton, owner of 9813 Lamontier Avenue.
Okay, Mr. Lofton, do you swear or affirm to tell the truth, the whole truth?
Yes, I do.
Okay, go ahead and proceed.
So I would like to address first, the structure is leaning. I called Mr. Bobby Cuevas and told him to enlighten me on that. And he said he came to that conclusion because of the excessive bracing I had on one section of the house because I was repairing something. I actually got the condemnation in the midst of repairs. I've repaired a lot of things. I've scraped all the paint off of the house. Mostly what I have left to do is repair the porches. I am a carpenter by education. I have done restoration for 53 restorations, 3816 Skillman Avenue in New York. For a few years, I have done kitchens and bathrooms. I have 25 years plus experience in construction, and I don't know how to do it wrong. I think this house is in good hands, and I just want to finish repairing the things I need to repair.
Okay, do you live at this house?
I am in a trailer on the side of the house. I am still repairing it. I was concentrating on the inner structure of the house more than the outer structure So I can see how they came by and looked at the outer structure and said, hey, this house isn't right on the outside. But I have put up framing around the windows. I've installed windows. I've installed doors. I've done most of the work. I mostly have to paint, put up gutters. I have put up siding. I can actually share some of those pictures with you on this internet if I am able to.
Do you plan on living there?
Yes, I do.
Okay. All right. Let me go over to Mr. Vanover.
Mr. Chairman, this is a condemnation of the main structure. There were permits pulled and closed as non-compliant on this premises. We don't object to more time. We would require that the new permits are pulled for the property.
Okay, he has down here 3 months, so we'd have, I better ask him if, is that what you think it would take to finish this? Mr. Lofton?
I still have more work to do inside, but on all the violations, I can solve all the violations.
Okay.
But I'd still have to, you know, renovate the inside of the structure later.
Okay.
Mr. Chairman, we don't object to 6 months once the permits are, but we would ask that the permits be pulled within 60 days.
Okay, so permits would be pulled by January 19th, 60 days, 2026. And abatement of the violations would be by May 19th, 180 days at 6 months, 2020 by 2026. Motion?
Okay.
So moved.
Okay, moved by Mr. Dank.
Second.
Second by Ms. Lipscomb.
Mr. Chairman, can you repeat those dates for me again?
I sure can. I think we had 60 days to pull the permits.
Permits, yes.
January 19th, and then May 19th, 180 days, 2026 to abate the violations.
Thank you. Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Ms. Lipscomb?
Yes.
Mr. Gallagher?
Yes. Okay, notice to be sent out within 2 weeks. Thank you.
Thank you.
Next docket is housing docket A 196-25, 3623 West 120th Street.
Yeah, Mike. Hello?
Application and fees are in order.
Yeah, Mike.
Notice of violation is interior exterior maintenance.
People know how to do it or not.
Hold on.
Sorry, give me 1 second. Notice of violation is interior exterior maintenance issued on July 8th of 2025. Appeal was received on August 5th of 2025, requesting for 60 days to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobs, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see the applicant in the participants panel, nor is that person present in room 514 this morning.
Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay.
Mr. Chairman, preliminarily, and We don't object to 60 days.
Okay.
Yeah.
All right, we'll take that on then. Motion is in order to grant 60 days. That would be till January 19th, 2026 to abate the violations. Motion?
So moved.
Okay, moved by Mr. Dank,
Second.
second by Ms. Lipscomb.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Next docket is housing docket A 197-25, 5615 Linwood Avenue.
Mr. Chair,
Yes.
hold on. She needs to call the case first. One moment.
Mr. Chairman, give me 1 second.
Sure.
Application and fees are in order. Notice of violation is exterior maintenance. Issued on June 30th of 2025. Appeal was received August 5th of 2025. Applicant was asking for 1 year to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see the applicant in the participants panel, nor is that person present in room 514 this morning.
Okay, Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Mr. Gates?
Thank you. Mr. Chairman, this is another case appeal where it was late and the city filed a motion to dismiss. City would ask that that motion be granted. No further continuances or anything of that nature. Given, because the appeal was done. I apologize. The violation notice was issued on June 30th, and the appeal was filed on August 5th. So therefore, it's outside the 30 days.
August 5th. Okay, Ms. Davis.
Yes, Mr. Chairman.
Okay.
There's a new owner that took transfer of this property on June 6th of 2023. We did accept this appeal on August 5th of 2025.
So
Only
you're,
thing I can attest to, if the applicant did come in earlier, that I was out on vacation sometime, or we did not have coverage within that week or so beforehand. And therefore, the applicant would have had to come back at a later date to file an appeal.
okay, would they be timely if they were there and were able to file it? Do you know?
July, it would have to been July 30th.
Do you think they were in there by then?
Mr. Chairman, I was out on vacation, so I'm not sure.
To the chair.
Yes, Mr. Gates.
The city's position is that this is not an issue that really can be where there's discretion. The board does not have the authority to hear a case after the 30 days. It's a matter of jurisdiction. I believe it's subject matter jurisdiction, but regardless, the appellate courts have said you simply cannot hear it. So whether it's because they didn't pay on time or because somebody was on vacation, which we don't have proof of, it really should be a hard and fast rule. In those prior cases that went to the appellate courts, in one of the cases it was a demolition, and it was denied because they had no standing. It was void. So the board cannot act after the 30 days. It has no legal. It will not be acknowledged by an appellate court. So all appeals after the 30 days should be dismissed, and that's the city's position as a matter of law. Thank you.
Yes, and I would agree with you, of course, Mr. Gates, if there weren't any extenuating circumstances or anything involved in it. I think the board still has some discretion here when it comes to what's the 30-day window. We absolutely, if it's violated beyond that, I mean, there's no argument. You're 100% correct that it should not be heard. But I think that sometimes there's extenuating circumstances that can happen, or maybe they didn't get the mail or something of that nature. They're not here to say that. So the only thing we have to go by is what Ms. Davis tells us on the receipt and whether there would have been enough time or not. And now she claims she wasn't in, there wasn't anyone here to receive it. I'm not sure what other way they could have notified it to be within that 30 days. Obviously, they were not. So I'm going to go to the board here for the moment. I'm going to ask. Let me ask Mr. Dank, what's your opinion on this?
The date that they did file the appeal is close to the deadline, and with that extenuating circumstance of possibly not being able to do it due to a vacation or somebody there, I don't know that it's not. I think that it's fair to hear this case and grant the appellant an appeal.
Discussion?
Yeah, Miss Lipscomb.
Why? Where is the appellant? Why?
Well, yeah, the appellant's not here, and
I know.
You're exactly right, and that's probably going to end up being. But I mean, what Mr. Gates is saying is that we shouldn't even been hearing it. Okay.
Yeah, I understand that.
We're probably going to end up with it being remanded anyways, because they're looking for a year, I think. Yeah, but but it's whether or not we even hear the case.
I
So
understand.
what's
I'm
your thought?
I'm less inclined to give grace about the deadline, you know, the 30 days, if the appellant's not even showing up now. So I'm not inclined to
Okay.
hear
Okay.
it.
I got you.
Chairman,
Yes.
this is Carmela speaking. I would like to say that if the applicant is not here, it may be also due to they received an email notice from Code Enforcement Attorney Robin Knickis stating that their appeal this morning will be dismissed.
No. Sure.
No.
We hate to
Mr. Chair.
disappoint. Right?
Mr. Chair.
Yes.
I guess just if the board is going to take the position that they have the discretion to go beyond the 30 days, can we please have that reduced to writing?
Yes. I guess we can do that if there is, and it's not, again, we don't want to violate that 30-day unless there's reasonable things that can happen. You know, we're living on a globe here, you know, so things can happen. And when they do, we want to be able to have that discretion to be able to say, hey, no, there are extenuating circumstances here as to why. When they're just blatantly, it's 30 days, there's no question, it's easy. So I think in this case, I will put it by the board. We'll see where it goes, but I'll make a motion that we uphold the city's motion that this be denied because it's not timely.
Mr. Chair, I would like to be heard in response to Ms. Davis's statement about my email.
Who's this?
My name is Attorney Robin Knickis for the Law Department.
Oh, okay.
So the motion was served to the applicant and Ms. Davis, and I'm happy to produce a copy to your legal staff. And it simply says, Dear Ms. Alela Wagner, attached is a copy of the Department of Building and Housing motion to dismiss your appeal to BBS. Kind regards. I did not in any way make any statement that it would be granted. I identified what the docket number was and what the contents of the attachment was. So that was a complete misrepresentation of what was sent, and I want that heard loud and clear by the board.
Okay. We still underneath the issue here as to whether or not there was within the 30 days, but thank you for saying what you said.
Mr. Chairman, this is Patty. You have a motion on the table to grant the motion to dismiss. The board has to have a so moved in a second.
Okay.
So moved
by Mr. Bradley.
Second.
Second by Ms. Lipscomb.
Mr. Bradley?
Yes.
Mr. Dink?
No.
Ms. Lipscomb?
Yes.
Mr. Gallagher?
Yes. Okay, it passes by whatever that margin is, 3-1. Okay, so notice will be sent, I guess, or not sent. I don't know how we handle that when it's not even heard. Okay, I guess however you handle it.
Wait, so what did they do? What did they do?
Okay.
Okay. Good.
Next docket is housing docket A 198-253842 West 134th Street.
Yep. I'm here.
Who is that? Oh, yeah,
Miranda.
I've been watching you for the last hour and a half.
I've been entertained by this. I have to tell, not entertained in a bad way. I'm just, I'm
right.
coming to you all with a very.
Hold on. Let Carmela calm down.
Yes.
Application and fees are in order. Notice of violation is condemnation of the garage issued on July 11, 2025. Appeal was received August 6 of 2025. Request between 45 and 60 days to complete abatement of the violations. Present for today's hearing, Chief Billing Official Tom Vanover, Russ Gates, and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record?
Thank you. My name is Kim Martirana. I am the owner of MXHM LLC.
Okay, Ms. Martirana, do you swear or affirm to tell the truth, the whole truth?
Absolutely.
Okay, go ahead and proceed.
Good afternoon, by the way. You all have a lot ahead of you. I'm toward the end, so you're getting there. So I am actually glad to have this appeal because I'm hoping you can help me. I have no problem with removing the garage. What happened was a neighbor's tree, a 120 foot live oak tree, came up at the root ball and it stretched 3 property lots. Mine took the massive part of the trunk that crushed the garage in question to be removed. The problem is, and I'm hoping someone on this panel can help me, I have laying across my part of the yard the worst part to get rid of. It is a 40-foot long trunk of a healthy oak tree, anywhere between 4 to 5.5 feet in diameter. And I have tried logging companies, I have tried the Amish, I have tried every avenue that I could think of to try to find someone to be able to remove this tree or cut this tree up. You cannot use like a regular person. My neighbor got the tree top, so the trunks are much smaller. But I don't know how to remove this massive part of this tree because I can't find somebody who will do it. Logging companies won't come up. I've tried as far south as Ashland because it's one tree and it's laying down. Tree companies oftentimes won't come if it's laying down. They only take them when they're standing timber. So I'm really here. The garage could be taken down in 30 days or less. I'm really hoping someone with your city maybe knows what company you hire when there's, trees down for the city. You've got to hire a crew that's got, or company that's got bigger chainsaws. You need a 4 to 6 foot chainsaw to take this apart because of the diameter.
There are some big companies that do stuff. I don't know, like Davy Tree and others. I mean, I can't imagine they couldn't take it out of there. But anyways,
I've been trying everybody, and I may not have called Davy Tree, but I can tell you I've called whomever I can find. I live in Geauga County. We've got the Amish. I've had a bunch of people go out. Sometimes they don't get back to you. Sometimes they never show either. And I don't like that my property's got this problem, and I don't really like to take up your time to do this, but is there any suggestion on who I could get to remove this tree? It's enormous.
Mr. Chairman, this is Patty.
Yeah.
Although the tree issue, I'm presuming caused the condemnation that Mr. Vanover will probably testify to. The tree itself and the property is not before the board, but the city does have an urban forestry department that may be able. I doubt it, but could, unless Mr. Vanover has another suggestion. But that is what's before the board is the garage. Thank you.
Okay.
Chairman, may I speak real quick? In response to that, I understand the garage is the issue, but this is a 4 to 5.5 foot tree trunk laying across a big part of the debris in the garage that we can't remove the garage until this tree is removed.
They take
The
down
root ball
300
that came up on the
redwoods
neighbor's
out in
yard was
California.
15
It can't
feet
be
tall.
done, trust me. It just
What's
got
that?
to get the right outfit. They take down trees that you can drive through. Mr. Vanover.
Mr. Chairman, yes, I would recommend reaching out to larger tree companies. I would also mirror Ms. Aston's recommendation to reach out to urban forestry. If they don't do it, well, I'm sure they won't do it, but they may have recommendations of folks that can.
Is urban forestry someone I can Google?
It's the City of Cleveland Department of Urban Forestry.
Oh, City of Cleveland. Okay, thank you.
And that being said, we don't, if the expectation is to demolish the garage, we don't object to, with the big tree, 120 days. I mean, this is a corporately owned property. It is an investment property and it is a rental. So
I
we
do
would,
want the tree removed and I want the garage cleared up. This is not for lack of trying. I'm just, you know what, and this is the first time this has ever happened, and I hope to God that never happens again to anybody with a tree on a garage that demolishes property. I get it. And
Yeah,
it's not life
it
and
won't
death.
take them long once you get the right person involved.
Exactly.
Yeah.
It's finding someone. You all had someone out there that was cutting the tree in sections, and that's how I ended up with the 40-foot section of it. When the incident happened, because they had to clear the wires. Do you happen to know if that's the city that was doing that, or is that a private company? Because they had the saws necessary.
Yeah, that's
At
the
the
private
time, I
company.
never asked because I didn't know I would need it.
That's the private
If,
company.
that information, it would, if it was contracted by the city, it would be Public Works.
Call Public Works?
City of Cleveland Department of Public Works.
Oh, okay, okay.
And then
That's kind of
also,
why I needed to talk to y'all. City of Cleveland Public Works. Okay.
also CEI has a company that they use, and I can't remember their name because they came out for me.
Yeah.
I don't know, Mr. Vanover, you know their name? You see them all the time.
I do
right?
not.
These guys were phenomenal. I'm telling
Anyways,
you what, those chainsaws
they
were
do
huge.
they do all kinds of big stuff. So, you know,
Mr.
whether you
Chairman,
can get
ask
them
for
or
a motion.
what's that?
A motion.
Oh yeah, a motion would be to March 19th, 120 days, 2026 to abate the violation. Good luck. Moved by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Notice to be sent out within 2 weeks. Thank you. Good luck.
Thank you. If you need firewood, you know where you can find it.
Right.
Have a good day, folks.
Okay, thank you.
Bye.
Okay, next docket is housing docket A 199-25, and that is 3568 East 153rd Street.
Application and fees are in order. Notice of violation is no permits. Issued on July 11, 2025. Appeal was received on August 8th, 2025. Applicant was requesting 90 days to complete abatement of the violations. Right. He said 199.25. Yeah. Present for today's hearing. Chief Building Official Tom Vanover, Russ Gates, and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record? Mr. Chairman, I do not see the applicant in the participants panel, nor is that person present in room 514 this morning.
Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay, Mr. Gates.
Yes, Mr. Chair. I was wondering if we could have Commissioner Vanover speak to whether or not this has been, the violation has been abated. It's not clear to me, and I was wondering if you could check on that.
Sure.
Yes,
Mr. Vanover.
Mr. Chairman, it does appear that the work is in progress and the permit has been pulled. So it looks like there might be a little more. We would not object to 30 days.
Okay, motion is in order to grant till December 19th, 30 days, 2025 to abate the violation. Motion?
So move.
Moved by Mr. Bradley,
Second.
second by, who's that, Mr.
Dank.
Is that Ms. Lipscomb?
No,
No. I know it's getting late, but it's not that late.
You were so far from the mic, I couldn't tell. All
Okay,
right,
fair enough. I'll do better.
Put one down.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes, yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. The next docket is time extension building, docket A 123-25, referencing A 127-24, 12704 Shaw Avenue.
Application and fees are in order. This is a time extension request from a previous docket that we've heard. Give me 1 second, Mr. Chairman. We originally heard this docket on November 20th of 2024. It was a condemnation of the main structure. The board granted the applicant until May 20th of 2025 to complete abatement of the violations. Today, the applicant is before us to request for additional time. They request an additional 6 months to complete abatement of that condemnation of the main structure. Present for today's hearing, Chief Billing Official Tom Vanover, Russ Gates and Dan Jacobson, Division of Code Enforcement, Department of Law. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record?
Hello, everyone. Robert Lewis, owner of 12704 Shaw Ave.
Hey, Mr. Lewis, do you swear or affirm to tell the truth, the whole truth?
Yes.
Okay, go ahead and let us know what the plans are.
Mr. Chairman, excuse me?
Yes.
Thank you. This is the last case in which we filed, the city of Cleveland filed a motion to dismiss. So I interrupted to ask that that question be decided first. The city's chair bases its motion to dismiss on the fact that the original appeal that the appellant had last year in 2024, that one was late. And as a matter of law, any action by the board outside of its jurisdiction is void, which was what the Court of Appeals held in Garrett versus City of Cleveland and Broadview Mortgage Company versus City of Cleveland. So the specifics on that prior appeal was that 30 days, it was May 17th was the issue date of the VN. The appellant filed its appeal on June 20th, which was more than 30 days after the appeal. So our position is as a matter of law, the action by the board is void. So that is why we filed our motion to dismiss.
Mr. Chairman, this is Patty. If I may, if the city could address whether or not that was made at the time of the prior hearing held by this board, I believe, was it January 16th, Carmela, of the prior?
We heard the original,
Whenever we heard the original.
November 20th.
Thank you. At the time of the original hearing, if that was raised and whether or not, if it was not raised, why this was not a waiver of that argument. Thank you. To make the record clear for this board. Thank you. Because they are asking to go back in time to something in 24.
Yes. Through the chair, if I can respond.
Go ahead.
Thank you. Through the chair to Ms. Aston, it's a reasonable point that you're making, but based on the precedent that was laid down by the Court of Appeals, anything afterwards is void. So I acknowledge that the argument wasn't made at the time, but as in the case of the cases that went before the board or the courts of appeals where a demolition occurred, even though there could have been a stay because the BBS had granted an appeal and given them time, even though it wasn't raised at that time, even though the city of Cleveland didn't make the argument at that time before the board of BBS when the appeal was granted, the Court of Appeals said that that decision by the board was null and void simply because it's a matter of law, it's a matter of jurisdiction. They cannot act after that time. So it's just something that the city is believes that it should be adhered to, and that's all. That's all.
Mr. Chairman, I'm hearing the city argue that it is jurisdictional and they did not have to raise it at that time and they are allowed to raise it now. It is up to this board to determine based upon the specific fact of this, whether or not it will agree with that. Thank you.
Okay. I'm inclined not to agree with that because it's and even though in the end they may say whatever, because we'll see where this floats to, but I think we should hear it. I'll ask the board their opinion.
I think it puts an appellant in a difficult position to make this motion to dismiss retroactive to a previous hearing. So I would vote to continue the hearing.
Okay, Ms. Lipscomb.
I agree. I believe the appellant should be heard.
Okay, Mr. Bradley.
Yes, I have to agree.
Okay. All right, so I guess we're going to deny the city's recommendation or
motion to deny the motion to deny the motion to dismiss, Mr. Chairman, if I may suggest.
Yeah, that is correct.
Thank you.
Okay. We'll take a vote on that.
I'll make that motion. I'll make that motion to deny the city's motion to dismiss.
Motion by Mr. Dink.
The move.
A second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay. That's done. So go ahead, Mr. Lewis.
Hello, everyone. Wow. Like you said, it's been over a year. During this time, none of this has been waiting on me. Between cyber attacks, whatever's been going on down here, I've been down here every 2 weeks or every month. I've had extensions. I filed for repairs. I made 2 roofs, 50,000. I've had to wait for an architect. You have to get a construction crew. Sorry, I'm nervous now. I have a project manager through Big Zoom. They're out of Florida. They hired the contractors for me. Windows, doors. You take a loan, 20,000. So I had to get an architect. That person had to come separate from the construction company. Right now, I'm still waiting on downtown because I've submitted all my paperwork. It is out of my hand. I'm waiting on permits. I'm waiting on them to go over the architect work to look at the scope to say it's okay. I've been doing everything ever since last year. And all of a sudden, you're telling me I missed last year a week, but this is like the second court time I've been to for an extension. I've been here for everything, but you're going back on last year when it was condemned and I didn't get an official letter. It was put on the building and it rained, whatever, kids come by. It's on a corner street. It wasn't there. I go by every week, cut the grass, check on it, whatnot. A neighbor told me, hey, it was paper up there. Went downtown, check on it. Took care of it, I thought. Past couple of months now, I've done electrical. Electrical is on. Now they cut it off and said the building is being condemned. I'm like, no, I'm just waiting on permits and everything. After I didn't pay all this money to get it up together. Most of the violations are done, but I had to stop because you have to have a certificate of occupation. Only way I can get that is getting a permit by giving the drawings of scope of work from an architect. Do that. I waited on the board to review it. People, some youth that was gone. I talked to Kayla. Okay, we're developing a online community board to let you know where your paperwork is at. It's been over 6 weeks. And now I get a court date. I've been had this court date. And then they tell me I don't have a court date. All of a sudden out of nowhere. What happened? I didn't drop the ball. And as I was told, as long as I was on top of all of my business, paper payments, everything was okay. Just wait. So I came out to see if I could get it expedited. There's no expediter. I'm like, okay, well, I would like to finish the work before 19th, but now with the weather changing, it's hard to get a painter. It's hard to get stucco or outside work done. Now the electricity's off. So that's okay. It can be reconnected. It was a mistake, but the building is up for condemnation. And I have an extension. So I'm lost on what's going on with the paperwork and filing or what. And now all of a sudden I didn't put $70,000 or more of my hard-earned work money into the building in less than a year. And you're telling me you're going to tear it down and it's new material. Why? Because I missed the deadline last year. How come that wasn't addressed? I mean, that's I would like to say.
We can find all that out through Mr. Vanover, but I think that what we're looking, if you're asking for an extension, and what do you need the extension to?
Well, I'm just waiting on permits. I have the architect papers submitted and waiting on Taylor or whoever in building the housings to go over the review board. And it's been over 6 weeks. And I'm still waiting.
All right, let me ask Mr. Vanover.
So, Mr. Chairman, this condemnation was issued last year. It was opened in 4/11 of 2024, and an extension was given. The permit that the appellate is referencing was applied for October 9th of this year. That's the 6 weeks that he's waiting for. There were no permits in place. I don't know what work has transpired other than there's no indication of any permits for even the electrical work. We would ask that you deny more time. You remand it back to the department. He can continue along with his project and his permits accordingly. But this has just got started in October of this year.
May I say that that's when I got the architect paperwork finally submitted. I couldn't do anything because you have to have the architect work submitted before you can even do any work. So occupancy of permit. So that's what took so long. But the work had been done. I didn't know I needed a permit to do the work. I was told I could do the work without permits. And it was like, okay, you can clean up, you can paint, you can do all this. You don't need a permit for that. Then it was like, you can't be in there because you have to have a permit of occupancy. You can't get that without the full scope of work.
Well, with the motion that Mr. Vanover was recommending is that you can still continue on and do what you're doing. So we make a motion as in order to deny more time, remand the property to Division of Building and Housing for any further action. Motion?
So move.
Okay, moved by Mr. Bradley.
Second.
Second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Ms. Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Mr. Chair?
Yes.
Thank you. I would just request that if it's possible to reduce to writing in your resolution as to why the motion to dismiss was denied.
Okay.
I appreciate that. Thank you.
Okay. Well, we'll get our attorney to work on that. Okay. We have approval of resolutions. We have A108 through A115-25, A119-25, A21-25, A157-25, through A5925, A16225, A16325, A19025 through A19425, A24625, A25025. What's that?
I think you missed 11725.
I did?
I
Where's
think.
that?
Just finish up.
Well, A11725 if I missed it, and A25025 and A26925. Is there anything else missed? We're good?
Motion for approval.
Motion, Mr. Dank. Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Miss Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, approval of minutes for November 5th, 2025. Are there any additions or corrections?
No.
Okay, motion.
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Miss Lipscomb,
Yes.
Mr. Gallagher.
Yes. Okay, is there anything else to come before us?
No.
All right, we'll adjourn.
Thank you.
Thank you.
Thank you. Have a good couple of weeks.
This is a 4-hour mission this day.
What was that? Okay, so,
Have a good
Patty,
week.
Patty, you can work on a response for us maybe.